Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. I'd like to give a disclaimer here. It's written in every single description to all of our content, which is we give opinions, we speculate, we give and voice and express opinions relative to the First Amendment to the United States Constitution, freedom of speech and freedom of the press. I'm going to give an opinion here in the court order on the alternate perpetrators. If you have not yet had an opportunity to watch our content regarding this court order, I've provided a link. Also, critically, if you have not yet watched our presentation entitled Trier of Fact, Trier of Law, published a couple of months ago on our YouTube channel, please do so. It discusses the role of the judge versus the jury. The judge makes legal conclusions. The judge will, for example, at the future trial, if someone makes an objection that another party is leading a witness on the stand, feeding an answer improperly to the witness, that will be the court's determination, the court's role to decide if that objection should be overruled or sustained. The judge has made many findings of the law thus far in all of the rulings that he has given since change of venue on the motions to strike the DP, on the suppression motions, on discovery motions, on the Franks motion, on the in limine motions. These were all findings of the law that the court made pre-trial. That presentation includes a standard jury instruction that can be found on the Idaho Supreme Court's website, what the court's role as the trier of the law is versus the jury's role, trier of the fact, to include such things as, is a witness on the stand credible or not credible? Is another bit of evidence, is it credible or not credible? Those are facts. The jury decides. There were two, in my opinion, findings of fact that the court made in the court order on alternate perpetrators. It appears on page 4, where, according to this court order, the defense has offered up 4 alternate perpetrators in the section dealing with 3 of them, which are, according to this court order, individuals who knew one or more of the victims, who lived within walking distance, who had some knowledge of the layout of the house because they had been there before. This is where the findings of fact, in my opinion, are contained. Look at footnote number 3 in between 2 large redacted sections of page number 4. It says here, the fact. So we see here, findings of fact apparently, the fact that these individuals lived within walking distance to the crime scene is not probative evidence, given that the perpetrator, singular, drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspected unalivers. The court is basically appearing here to make a finding of fact that the state of Idaho's rendition of the facts of the case is correct. That is the jury's role to determine, number 1, how many unalivers, is it 1, is it 2, is it 3, is it 4 or more, are responsible for the catastrophic events at 1122 King Road. And secondly, if the unaliver or unalivers walked to the crime scene or drove. That is also the province of the jury, as is, was suspect vehicle 1? Is that Mr. Kohberger's car? Is it someone else's car? Did it have anything to do with the crimes or not? All findings of fact of the jury. Again, I give my opinions in this matter. This is Kathy. Thank you for joining us here today.